Morning, everybody, and welcome to this hangout, which I guess we're all going to figure out what it's about as we go through it. It's very exciting to me that our journal, the Sybaris Journal, has done this special issue on intellectual property and art, and that, as appropriate, we're having a discussion about it in a new technology forum. So I'm very pleased about it. Again, my name is Eric Janis. I'm the dean here at William Mitchell. And I wanted to introduce everybody. I think we probably all know each other, but for anybody else who might be watching, Alma Robinson.
Hello.
Hello. Nice to meet you. And Executive Director of the California Lawyers for the Arts, a graduate of Middlebury College, a favorite of mine since my son went there, and Stanford Law School. And Alma has a long history of involvement with law and the arts. The second person I wanted to introduce is Jared Sherlock.
Hello.
He's an illusionist and the owner of Sherlock Studios. And Jared was recently awarded the Minneapolis Indie Performing Artist of the Year. As I understand it, and I hope I'm not stepping over any bounds, is that Jared is a magician, or what we would know as a magician or an illusionist, right?
Correct.
And we'll be talking about the implications for that form of art, of intellectual property law. And thirdly, Professor Rebecca Tsosie, Arizona State University. Welcome, Professor Tsosie.
Thank you.
I was just in your fair city a couple of days ago and was informed that it was actually chilly there.
Yes, it is. We're really suffering with the 70-degree weather, you know.
I know. I felt sorry for everybody there. Anyway, Professor Tsosie teaches in the areas of Indian law, property, bioethics, and critical race theory, and teaches seminars in international indigenous rights and in the college's tribal policy law and government masters of law program. So welcome, everybody. Finally, I want to introduce our moderator, Sarah Howes, who is a student here at William Mitchell in St. Paul. She is editor-in-chief of Sybaris, the Intellectual Property Law Review here. She's a playwright, non-union stage actor, theater company owner, and JD candidate. And Sarah is going to be our moderator. So, Sarah, I'll turn it over to you, and thank you so much for organizing this and getting everybody together. We're very excited about it.
Oh, thank you, Dean Janis. All right, so just to get started, I think we'll start with Alma. Alma, if you don't mind just telling us a brief synopsis of, what it is that you wrote about for our issue, and just a general topic about what you're going to talk about today.
Well, I was very excited when you invited me to write this law review article on the Resale Royalty Act. There's so many layers to this story that it was really challenging to me to figure out how to synthesize it and make it a compact story. We have the California statute, which is unique in the United States, but uniquely in the world, our country does not have a federal statute. I say uniquely in the world, I'm exaggerating a little bit because 70 countries have passed a national law mandating resale royalties for visual artists, but the United States has not. There's some other outliers, China, and I think Canada is now considering it, but most of the art market is involved in finding artists and paying them resale royalties. I don't see why we can't figure that out and participate in this international exchange of royalties, which our artists are left out of on the national stage.
Wonderful. All right, and then let's move over to Jared Sherlock.
Yeah, great. Thanks, Sarah, and thanks, Dean Janis. I appreciate the introduction, and it's good to be with you, Rebecca and Alma. I guess I'm the odd one of the group, going from the magician's angle to less discussed about topic, but I was really grateful to be a part of this. In my undergrad time, I wrote a thesis on this topic about intellectual property law in the magic industry. At the time, there were only a couple of published law articles on the topic, only maybe one or two. And since then, there's been a number because of some recent activity related to copyright law. But the challenge has been in the magic industry that the magic secret has always been viewed as an intangible resource that by explaining the secret, which is needed to protect it in patent law, you're depleting the value of the secret itself. But with magic, there is part performance, and then there's also part secret. So a lot of people over the years with a number of exposures, like the Masked Magician, have argued that the exposure by revealing the secret is damaging the industry, the competitive advantage that people have, and making it difficult for practitioners to make money. But most recently, with a major suit with Teller in Las Vegas, he became the first magician to ever successfully defend a magic trick under copyright law in the U.S., particularly since it was revised in the 70s to include choreography. So it seemed like a good time to readdress it, and so my note proposed that protecting a magician's performance, not the secret from disclosure, can be a very effective way in safeguarding a magician's finances and maybe even their morals as practitioners. So I guess just exploring how copyright might be better evolved to handle the complex atmosphere of the magic industry.
Wonderful. Thank you, Jared. And then Rebecca, Professor Tsosie?
Yes. Well, thank you so much, Sarah, and thank you so much, Dean Janice. It's really a pleasure to be part of this group, and I really appreciate the expertise that my colleagues have on this panel. I know I'm going to learn a lot from them as well. I'm a scholar of federal Indian law and not a scholar of intellectual property law, although I've had to learn a lot to do the work that I do. So I am looking in my paper at the sort of intersection of cultural harm and identity harm and the various protections on the one side under intellectual property law, on the other side the arguments that are being made under federal Indian law and international Indigenous rights law. So roughly speaking, much of the problem deals with cultural appropriation as we would frame that, but there's a real hard line to draw. I mean, it's very hard to draw this line between what is culture and what is art, what is innovation and what is really part of a cultural art form that can't innovate. It must remain in its sacred nature. And so when I was in international discussions last year, there's an effort to create an international treaty on this idea of traditional cultural expressions. And the conversation there struck me as very interesting because different nation states have a certain view about cultural art forms. And in the United States, we're this pluralistic, multicultural, so we tend not to privilege culture in the same way. So, roughly speaking, that's what my paper is about.
Wonderful. Well, thank you so much. I'm looking forward to, and just so the people viewing this understand, is that Jared and Alma have finished their papers, and Rebecca is still working on her paper. So a lot of the questions that we have prepared are for Jared and Alma, but hopefully we can have all the participants can have some questions for Rebecca as she's developing her paper, so that'll help her out. Thank you so much, all three of you. So to get started, Alma, can you tell us, why did the Bay Area Lawyers for the Arts, now California Lawyers for the Arts, advocate for the resale royalties back in the 1970s?
Let me say, first of all, that Bay Area Lawyers for the Arts was born out of advocacy. A group of activists, artists, and lawyers were very concerned about the imbalance in the marketplace for visual artists. And as we know still today, emerging artists often don't look after themselves legally. They may, I'm sorry, I'm getting some messages from Google that I don't understand. Can you still see me? Am I here? Okay, all right. So emerging artists need protection from unscrupulous dealers. They often get taken advantage of by galleries. They're the last to be paid and so forth. They sign contracts and then read them later when there's a problem. So our organization, which was the third of its kind nationally, the first two were Volunteer Lawyers for the Arts in New York and Lawyers for the Creative Arts in Chicago, and then we came along third in 1974 as Bay Area Lawyers for the Arts. The idea was to not only help artists with legal services, but also with educational programs and advocacy. So our board of directors went to work with the state legislature to establish moral rights for artists, as well as the Resale Royalty Act and other protections so that artists wouldn't be paid after all the other creditors in bankruptcy, et cetera. So it's been a very challenging road to try to protect the Resale Royalties Act, but it's part of our DNA, and we've gone to bat for it several times now. And with amicus briefs in court, we can talk about current case that's going on a little later, as well as educating the public, educating collectors and auction houses why they should try to support artists in this way.
That's wonderful. Can you talk just a little bit briefly about when you first advocated for the right? What were some of the challenges that you faced back then? Are they still some of the challenges you face today?
The first legal challenge was almost right away, 1980. Mm-hmm. There was a suit in federal court claiming that this law was preempted by federal copyright. We did an amicus brief, and that challenge was beat back. So the court said, you know, California has the right to experiment with this, and we have an innovative state in jurisprudence. And here's an example of California trying to lead the way to something that we felt could have a national impact. Currently, there's a challenge on a different constitutional basis, which is the Dormant Commerce Clause. An attorney sued Sotheby's, Christie's, and eBay. You know, how could you line up a bigger team of opponents and for not paying royalties to his clients? The district court judge decided it was unconstitutional based on the Dormant Commerce Clause on a motion to dismiss. That, of course, was appealed, and we're still rambling around in the Court of Appeal, Ninth Circuit, where they've now decided to have an en banc motion hearing to discuss this as the whole court. So it's interesting because the judge who dismissed the suit on Dormant Commerce Clause grounds is now on the Court of Appeal. She was promoted shortly after this case, and so she had to recuse herself when they were discussing our issues. But I went and heard the hearing in federal court last spring. It was very exciting. It was in April, and there were an amazing array of attorneys on the other side with this dormant commerce issue. Our claim here is that there's such a big and serious Commerce Clause question. You couldn't just throw it out on a basis of hypotheticals that the other side brought to the trial court judge without having a full evidentiary hearing. So we hope that the case will actually be remanded for a hearing, and by the time all of that happens, because they only seem to do one thing a year, by the time it's remanded and there's another hearing and trials and discovery and so forth, by then we hope we'll have a federal law in place and this will be moot. That's our hope.
Good, and good to hear an update on the case. And now, the topic of this panel is underserved artists, right? So people that are being underserved by intellectual property law. Can you explain briefly why it is that visual artists are different than, say, a musician or a performing artist?
We think there's an important equity issue here because other artists do enjoy returns on future sales from copyright, from multiple copies, from having their music played by a radio station, or even for an exercise class. BMI and ASCAP are prowling, looking for those opportunities to collect for those artists. There's nothing like that in place for visual artists. One of the flaws of the California statute is that there is no enforcement mechanism like BMI or ASCAP. And we hope that if there's a federal statute, that some sort of authority will be set up to um, administer royalties, find the sales, compute transactions, find the artists. It's been a weakness in our system in California. We hope the federal legislation addresses that.
Mm. Now, can you speak of any instances where artists have benefited from the California law?
There have been numerous artists that have collected resale royalties, and not all of them are wealthy artists. There's a woman named Ruth LaSalle, unfortunately, she just passed a year ago. He was a very well-beloved sculptor in the San Francisco Bay Area, did a lot of public art, and she got a $5,000 royalty when a very prominent piece of real estate in Ghirardelli Square was sold, and she had a fountain that was part of the architecture of the building. So she was able to claim a resale royalty, and it was $5,000, which she invested in an art school in San Francisco. She donated that money to a school. In other instances, there have been some successful litigation where artists have gone to court to claim the royalties, often connected with buildings and real estate which is sold, but also visual artists find out that their work has been resold for $1,000, that's the threshold, and they're supposed to get 5%, which at that level is only $50. But it's still meaningful. It encourages artists to continue working. They know that they're having some opportunity to realize some benefits down the road if their work is successful. So we did a survey last year of artists, and many of them said this is an important incentive to them. And they also want to have a legacy, the way people in other professions do, something to leave to their heirs and to their estates, or to make a name for themselves. So visual artists have been left out of this. It's been frustrating for some, and we feel like it's time for our country to also participate. As it was said in a recent report by the U.S. Copyright Office, a whole generation of U.S. artists has not participated in foreign resale royalties because we don't have reciprocity in the international marketplace on this issue. Similarly, foreign artists aren't able to recoup resale royalties when their work is sold in the U.S. market. And the very same auction houses who complain so much and say this is such an administrative burden don't seem to have problems administering the law and the royalties in 70 other countries, including all of the countries in the European Union.
Now, you mentioned the Copyright Office's report. So they wrote a report back in the early 90s, and then they wrote another one just a couple of years ago. I know in the original 90s report, they actually said, you know what, let's still figure out if this royalty rate means anything. And then now they've changed into they're supportive of adopting the royalty rate and act. So can you talk a little bit about why it is they changed their perspective?
Well, it's very interesting and somewhat pragmatic, or you could be cynical about it. But back in '92, when the first report was issued, the Copyright Office had been asked to do a study that was part of the statute that legislated VARA, the Visual Artists' Rights Act, in 1990. So there had been effort to include resale royalties in VARA, but it was knocked out, and instead the Copyright Office was asked to do an analysis and report, which they produced in 1992. They said at that time, there are only about 36 countries that participate in this. Let's wait and see what the European Union does and revisit it. But for now, we don't really think that there would be that much benefit for American artists to be part of this. But if the European Union gets fully engaged, then let's revisit it. Well, several things happened. In 2001, the European Union issued a directive that mandated that all of their member states have a resale royalty. And by 2012, in fact, all of them had, and all of those national laws provide for benefits for the heirs of an artist as well as living artists. So in 2013, the Copyright Office issued another report. They took another look. They had hearings, comments. Our organization, along with many others, commented. And they said, well, things have changed. Now there are over 70 countries that have resale royalties. We feel like the United States should also have a royalty, but let's take baby steps. Let's only do it for living artists, and then we'll revisit it again and see what we should do about the estates of artists who have passed on. Should they also participate? I think that's a pretty serious flaw, actually, because that means that some people might say, well, let's just wait until John Doe dies, and then we won't have to pay the resale royalty. That's the worst case analysis. But it also means that John Doe's heirs aren't going to participate when, in fact, the art market for his work or her work is going to increase after the artist dies. So it's actually robbing the artist's family or estate of the most significant ongoing legacy that they could have from the resale of their work. So that's one problem. The other problem with the current legislative proposal in Congress is that it only applies to auction houses, which means that people might decide they would rather just do a private sale and not have it recorded. There wouldn't be any statutory obligation. But if they put it in an auction, then it's going to be subject to this resale royalty, which is, again, a limitation which doesn't help the market and might skew the results.
Well, something that I thought was particularly interesting about your article is that in Minnesota, we have a good number of people that come through, Minnesota Lawyers for the Arts at Springboard here are visual artists, right? It probably represents about a third of the clients that we help serve. And even looking at the Creative Vitality Index, which was put out in 2013, which measures a locations or a metropolitan area's ability to support the arts, it pointed out that over half of the amount of money that we bring in for our creative economy is through retail sales. And if you look at all the retail sales, things like theater tickets, sales at art galleries, and so it shows that not only is this important in the sense that, oh yeah, there's some visual artists that are impacted, but I think that it's more artists than people think. I think that when people think of copyright law, they think of musicians, and that, oh, copyright is serving musicians, but there's not a lot done for a large percentage of American artists who are in that realm where they are doing one-time sales. Can you talk a little bit about how, that's just a little bit of a thing on Minnesota, but can you talk a little bit about what the kind of breakout is for artists in California as well that you work with?
We think that about 35 to 40% of the people we serve are visual artists. And it's interesting because they work singly. They often work alone, and they do produce works which are unique, and they put a lot of labor and love into their creation. So their work sometimes is like their progeny. It's something that the moral rights concept, which says that yes, you purchase this work, you own the physical object, but the artist also has a connection to it. There's the right of paternity, the right of integrity, and then the resale royalty is broadly defined as part of that whole rubric of moral rights, because the artist has a continuing relationship and should know who's buying it and for how much, and participate in the increased value and appreciation of that work. Otherwise, they are being exploited. And if you look at the history of this law in Europe, there are a lot of stories about artists whose heirs were looking on and seeing their father's work sold for many times what it had been purchased for originally. It's simply not fair that visual artists aren't allowed to participate in this increased appreciation of their work. So we're really concerned about the equity and justice of the whole situation.
Wonderful. And then our final question for you is, what is California Lawyers for the Arts doing right now to tell artists and sellers about the law in the meantime?
Well, we're telling them that it's being tested constitutionally, but it ain't over till the fat lady sings. Basically, we're saying the law is still in effect. Even if these defendants are able to get suit thrown now it only affects those defendants, and so it's still in effect for other people. This is one theory. But for the time being, we're suggesting that people continue to obey the law. It is the law of our state. The law is that if the artist resides in California, is a California resident, or the seller is, then it should apply. So even sales that are out of state would apply if the seller is a resident of California. So that's the nexus by which our attorney friend has gone out to place the long arm on Sotheby's and Christie's and eBay. eBay, by the way, claims they're not an auction house. That they're like a messenger, they're a carrier, but they're not really selling. So that's an interesting. They're trying to distinguish themselves from Sotheby's and Christie's. I would have thought they were doing auctions, but who knows? Anyway, it's an interesting little wrinkle.
Yeah.
But we're telling people to, continue to pay the royalty. If you like, put it in a trust fund or send it to the California Arts Council, which is the default. If you can't find the artist within 90 days, you're supposed to send the royalty to the California Arts Council, which posts in trust for the artist for at least 7 years. If they can't find the artist, and we're not sure that they have the resources to really do this work properly, that's why we think there should be a private organization that administers these royalties, just like ASCAP and BMI and others. The Arts Council is really not set up to do that, and in fact, the funds default to a fund for public art if the artist can't be located within 7 years. So back in 1986, we did a study and took the Arts Council list and found most of the artists that were sitting on their list and told them to go and collect at the Arts Council. But they need some person power to be able to do that work ongoing.
Well, thank you so much, Alma. Does anybody have any questions for Alma before we kind of move on to talking about magic?
Yeah, I guess I had one. Alma, it's very interesting. I see a couple of corollaries between actually the illusion builders and what you're talking about with the appreciation of their work and being part of that process. But I was curious, when you mentioned developing like a governing organization like ASCAP or BMI for visual artists, has there been any study that shows the success rate like increasing in case victories and like positive progress in what you're talking about within the legal system once an institution like that is involved in the dialogue or there to sort of provide reference for the court? I don't know if that question is clear, but I guess I'm looking at has there been any sort of way to determine like the value and the contribution of like a governing system like that in the dialogue with the courts?
I'm sorry, I've got a little technical problem. This thing is running my battery down a lot. So let me see if I can repeat the question and get back into the view here. Am I in your view now?
Yes.
I didn't want to lose the connection while we're in the middle of this. I'm sorry, Jared. What was your question again?
It was just about, you mentioned the ASCAP and BMI and developing or creating an internal governing organization that at least can sort of create a set of rules and assist in enforcing the royalties that you're looking at developing for these visual artists. And I was wondering if you have been able to study or if there are any studies out there that indicate that that the legal process improves in terms of in favor of what the artists or the practitioners want when there is an organization like that in play.
Well, that's a really good question. We were approached by a team of lawyers a few years ago saying they wanted to set up an administrative body exactly like what you're describing. And they discovered that if it was just limited to one state, like California, there wasn't enough volume to justify the amount of technology that would be involved in setting up registration processes for all of the individual works of visual art that are created by an artist and then tracking them with their chain of title to try to figure out who owned it, when it was sold, and all of that. So what we have now, by contrast, is a very loose self-enforcing mechanism. If an artist happens to discover that her work has been resold, then they might approach the seller and say, hey, where's my 5%? And failing that, it's up to the seller, through goodwill, through their own initiative, to find the artist. And they may not have been the person that bought it originally. It's changed hands several times. And so then eventually money might or might not end up with the California Arts Council. Now, the Copyright Office has recommended having some kind of administrative body similar to the ones, the societies that administer these rights in Europe. We had a very interesting trip to Paris last spring to talk to these folks and find out how they administer this huge volume of transactions that flow through their offices. How do they find artists? And it seems to work very well. They collect an administrative fee, which is what the California Arts Council does not do. They don't have really the resources to administer the work that they're supposed to be doing on behalf of artists. So the societies collect a fee and then pay over the net income from the royalty to the artists. So they have huge databases of artists that they work with. In France, for example, it's not just the French artists, but also artists from all over the world who are collecting royalties from transactions that occurred in France. So you see that there's a big global marketplace in resale royalties, and unless you have a good apparatus set up to administer it, it's going to be pretty inefficient. But that's one of the reasons that I think is troubling about the Copyright Office saying they only want it to apply to living artists. What's the difference between finding the living artist and finding their estate? How much more trouble is it to figure out who their heirs are? And often people who do inherit an artist's copyright or royalties already know that, and so they're already involved in a process to be a beneficiary when the estate is probated. So I don't think it would be that much to add. I think the troublesome part would be looking at how inefficient our Congress is right now. If you could get a law through next year, would you want to have to revisit it 2 or 3 years later? No, you'd rather put the full package together to begin with, and that would include the administrative body, full coverage of artists and heirs, etc. And the Copyright Office also wants to make a requirement that you register your work with copyright, and so that's good too, because it gives a way to identify and authenticate the artist's ownership of the work, when it was first made, and so forth. So I think they have some good ideas, but we need to flesh it out a little further with Congress.
Okay.
Well, the living artist thing is funny because, as the old saying goes, most of these artists have to die for their work to become so famous.
Yeah, this is just sad.
That's when the market closes, right? There isn't anymore, so it becomes a more precious commodity.
Right.
Exactly right. Yes, and that's not very magical either.
No.
All right, so let's, just for time's sake, let's move over right now and talk a little bit about magic, which I always like saying. So Jared, we just got done talking about, kind of how visual artists are not being served right now with intellectual property laws. The lot can be said about the same situation for magicians. And so why aren't magicians and their performances being protected currently by U.S. Intellectual property laws?
Well, magic secret and the practitioners have sort of been operating in a negative space of intellectual property law because of the unique and complex nature of the magic trick, which I kind of explained at the beginning, that it's that a magic trick's success partly depends on the audience not knowing how it's done. But most of intellectual property law, particularly in the U.S., is protected by having all of the details, whether it's a patent that's drawn out very articulately to show how it works to make it different than somebody else's patent. So by exposing the secret, you're kind of damaging the value, and so a lot of magicians don't pursue patents, although a few have. but then another person could go to the patent office and create it, and then there really wouldn't be much of a way to enforce that protection. In terms of copyright law and trade secret's, I guess, an easier one to cover. It's not sufficient to protect magicians for a couple of reasons, but the main reason is that trade secret, and again, I'm not an attorney, a practicing attorney, or even a law student, so all of our listeners are pretty informed in this, I'm sure, but I'm here mostly just to frame the ethical challenges and the cases that have happened, in hopes that maybe it produces the right discussions that would then benefit both magic, and maybe there's a trickle down from one of Alma's successes that comes in. But with trade secret, there has to be a reasonable effort to protect the secret itself. And the courts don't recognize an industry environment as if the secret is discussed within an industry, say magicians discuss the secret, it invalidates that clause of making a reasonable effort. So trade secret then fails. And with copyright, the main issue is a little bit what Alma touched on, in that there is a big part of it, as you guys know, that it has to be sufficiently original, and it's very difficult to track with the history of magic. It's a pre-science, so going back. Some of the earliest exposures in the magic industry are the 1500s. And it's very difficult to track the ownership and who is creating original work and who isn't. However, there have been recent developments in protecting the performance of the trick, not the secret, so the choreographic element image. So we've had one victory, but those are the main reasons why the magic secrets aren't being protected. And like Alma pointed out with the visual artists, I think that it's a small enough niche market where there just isn't a lot of money to develop these big governing organizations and databases. And I mean, candidly, there are a few magicians, a handful in the world, that can pay top dollar legal fees. And I think that that's it's a lot of work for a lawyer with not a lot of money on the other side. It's my sort of candid personal thing. Teller spent hundreds of thousands of dollars, but there are only a few magicians in the world that are going to go to that length to pursue, protecting their material.
So this is kind of a fun question. Best person to answer it. Can you explain to the audience, what is a magic trick? I mean, other than the fact that you have, internal powers where you can move things with your mind.
Yes, I went to Hogwarts. It's made it much easier. No, a magic trick. And most people are kind of familiar with it, but breaking down more what it is and how it's created is, if we're being philosophical about it, it's showing the world working incorrectly. It's a visual performance, usually using some sort of apparatus or objects that show something in the world working incorrectly. So whether it's gravity being ineffective because the lady is floating up, or somebody being able to bilocate or disappear, or make some object change or transform. So that's does that answer your question? I don't know.
Yeah, it does. Okay, let's see here. So, you mentioned to me that, 1976, Congress kind of added the choreographic work, things like dance, movements on a stage. Do you feel then, because of that copyright law, even though it wouldn't protect the actual inventions, is actually the best protection for a magician to pursue?
I do, yeah. And that's what I think other attorneys that have since wrote articles on the topic, they seem to be in agreement with that too. I think that the consensus is that copyright is the best suited in the intellectual property law format to protect magicians' secrets in their current form by protecting the performance, and that it's within the spirit of that law's design that it would extend to magic tricks and their performances. It doesn't totally protect them, but it's, again, with the limited resources and how complex it all is, with this recent victory, I think it is, yeah, because the magic trick is part science and part showmanship. There's the trick portion, and then there's the performance. And people go to the theater to be amazed, and that's the fundamental impulse. And so a magic trick is beautiful because it accomplishes that. But you have to be there has to be showmanship. There has to be a presentation. That's why people go to the movies. It's emotional exercise, and if you can protect the artwork, the delivery of that successfully, I think that's what's going to keep magicians in work and give them their competitive advantage and incentive to keep performing, not just the secret itself. Everybody knows something about a magic trick and knows a secret, but you go to the theater because you want to see the performance, not just the trick. So I think that copyright, in terms of this, with Teller's recent victory, protecting the performance, it illustrated that it's a good fit for this.
Now, you also, Jared, in addition to being a magician, you actually, well, you do dance in your shows, correct? And then you also,
but yes.
But you hire professional dancers to be part of the show, and then you're a trained actor as well. So can you talk a little bit about how, maybe what people expect when they go to a magic show? There's like a fine line between the difference between going to see a play and seeing a magic show?
Yeah, a little bit. I mean, I think people, it depends on what you've seen. There's people have seen like The Birthday Party Magician, and there's David Copperfield, and there's a bunch of us in between. And when you go to see a magic show itself, they're short plays. It's like several short plays, or you could consider a magic trick each one like a song. It's got the beginning, the middle, and the end, the climax, and it's its own little vignette. And I say that most magic shows are an assembly. It's like seeing a concert of very short plays. And so I think that's the main difference.
That's good to know. Okay, so then the American performer Teller, he was recently became the first magician to successfully defend a magic trick in our court system. And why was he successful?
Well, I think there's a number of reasons. I mean, there was an article that pointed out that it was just, timing is everything, and Teller may have been just the only and perfect candidate to win, to sort of set this unprecedented thing, because Teller is considered and is not arguably, but for sure, one of the greatest living magicians of all time. And he happens to be maybe the most talented magician alive today. And he happens to be very successful, so he has the resources to pursue this industry. In specific to the trick itself, the trick shadows, which is amazing if you ever get a chance to see it. In my opinion, it's the best magic trick I've ever seen live. I mean, when you see it in the theater, the gasps from the audience, it's done in complete silence, are magic themselves. But he's had that trick in his repertoire since the early 70s. So in addition to his being a well-known expert on the topic, which I think benefited him, he has done the trick for a very long time, and there's photos and performance evidence of it. And in the 70s, he actually filed copyright protection, so 30 years prior. And he did not reveal the secret. He filed for the choreographic elements. And so he sketched out a crude drawing. It's actually pretty funny because he does his hair and his like angry smile and everything. But he's holding a dagger, and it shows the canvas and the flower that he uses in the trick. Basically, the trick is that he cuts a rose to pieces by cutting its shadow with a knife that's projected onto canvas. And so he sketched that out and submitted it. It was one page, and so that had been in file. And then on top of it, he had the added help of the guy that was stealing from him and promoting his own version of the trick. Went missing for a very long time when the suit was filed against him, and so it started to make it look very messy for that individual. And when they finally did serve him overseas, then he showed up, and then began to argue many different angles as to why Teller had no claim there, which I think a lot of those are like breaking basically the basic rules of if you want to win in court. So he had a little bit of help there, yeah, I think those are the main reasons why he was successful. But mostly having it filed 30 years ago, and having it being such a well-known trick and being such a high-profile individual. Yeah.
So then, my last question for you, Jarrett, is, this is normally law reviews don't publish non-lawyers or non-law students, and but given the issue and given the needs of artists, we wanted to publish you because, one, you're very smart, and two, because I think that the court system could benefit from hearing what an artist actually wants, or how what they need for their actual practice. And I was wondering if you were going to speak, to, let's say, in front of the Supreme Court panel of the judges, what would you kind of say to them about, what would you need to have a competitive advantage as a practitioner in the field?
Well, first, I would be trembling if I was addressing the Supreme Court panel, so I could do that now. But to have a competitive advantage, or at least to retain the incentive to create jobs and to work hard, would be to know that there at least are some means of protecting the performer. I've become more in agreement that the secret isn't as important, and it isn't putting people out of work. But there, exposure and this whole thing revealed the notion of character in practitioners. And it's like Alma pointed out with the artists, and the sellers, that they can go ahead and just sell. They can go and sell, and it's up to them morally to either reach out to the artist, to pay them a royalty, or to involve them in the conversation. The same thing happens with illusion builders, and I've had the privilege to get to know the top illusion builders in the world. I mean, Jim Steinmeier, he's invented almost everything for all the Broadways, from Mary Poppins, to Aladdin and everything, and making the Statue of Liberty disappear. And they're world weary. They're tired, and I know them, and they're personal friends, and some of them, and just colleagues, and they've been exhausted. And there's notebooks and notebooks of this brilliant man's engineering and scientific creations that people could go see in the theaters, and he rarely doles it out and sells it to people anymore. And it's very selective, and it's because he wants to protect his work. And then it's a trickle down. So if you have the best people in the industry who are creating these bright minds that are creating this intellectual property and content, but they're not producing because there isn't a good means of protecting it, it affects everybody. And so I guess I would love to see more cases like Teller's successful in protecting the choreographic elements, so that people would be more inclined to create and share their work, and more trustful of the other practitioners. I think it would just breed a healthier, more accountable atmosphere. But I think magic's going to push forward either way. It has, and it's still continuing to be successful without it. But it would, I think, it would make the art form a lot more successful. It would be a much more healthy environment.
Jared, may I ask the question?
Yes, of course.
An infringement case? How was it shaped when it went to court?
I apologize. Would you repeat that? I'm sorry.
Was it a case where the magician, the illusionist Teller, was claiming somebody had infringed his copyright? How did he bring it to court?
Yeah, he did. He first, and it should be noted too that he did try and settle out of court just personally, not with lawyers. He reached out and offered a great sum of money, just because of knowing the track record, knowing that nobody had won. And the guy was very rude and said, "Yep, you can't stop me." And so then Teller was like, "Well, I've got the time." But he did. He filed that it was infringing on the copyright that he owned for the visual, the choreographic art form that he had created, this story of cutting up the rose's shadows. And so he did not argue at all that the secret was being used. He actually openly said in the court that he's used 3 different methods over the years to accomplish the same trick, and that he's quite certain that this other a magician wasn't even using the same method, and that wasn't what Teller was concerned about.
That's very interesting.
What's that?
I said it's very interesting. Yeah, it opens up a whole new world of the illusion of copyright.
Yes, and well, and with the with your discussion of royalties, for those illusion builders, the same sort of thing would then be possible. If I buy a used illusion, I contact the illusion builder and pay them their royalty and performance rights. But when people are ripping off the magic or just unaware of the practices, then those illusion builders created this expensive apparatus once, and they receive one performance right, but maybe 6 different owners own it and use it, and so there's a lot of cash that's left, on the table.
But you do pay for rights for reuse?
I do, and the illusion builders have had to take it on themselves to either to get that. Like I know that Jim Steinmeier would say that he's fought very hard over the last 20 years to get that from the magicians that were buying his props, and he only requests a one-time royalty from the original purchaser, but they don't have the ability to go and track down, everybody. So if I commission an illusion, I would pay him the royalty fee, and then the builder who's assigned to build the apparatus would also normally pay a fee, I believe, to be the exclusive builder or to be a designated builder of that prop. But it's all informal industry norms that are establishing these boundaries.
Very interesting. It suggests that we should have some talks about collaborating. It would be fun to take you guys to Hill to Congress in Africa.
It would be a privilege. I'd love to talk more about it.
Visual artists and illusionists. That could get some attention.
We're a regular circus, yeah.
Well, speaking of which, let's, now that we've talked about visual artists and magicians, I know we don't have much time left, but I would love to talk to Professor Tsosie about, I guess just to get us started, is the whole point of this discussion is artists that are underserved by current intellectual property laws, and you mentioned a little bit about how there's just not this connection to cultural heritage, and then also this connection to art form as this commercial product. Can you talk a little bit about why it is that Indigenous peoples are most underserved, why they're underserved by intellectual property laws?
Absolutely, and I think we probably only have about 5 minutes. Is that right?
Okay. Yeah, that's fine.
Okay, so I want to be very responsive, and first of all, I want to thank Alma and Jared. I actually had no idea about the extent of what was happening in either area, and so the first thing I would say is that Native artists, they're full citizens, and obviously they have all of the same needs for those levels that you guys are working on in terms of resale royalties, in terms of, magic. I mean, obviously that world is going to serve Native artists to the extent that they're doing those art forms too. So I want to thank you for the work that you're doing there. And Jared, you said that magic dates back to the 1500s. And so one of the questions in the back of my mind, which we can talk about, some other time, is whether or not there's a culture among magicians and whether or not that's a form of knowledge that's been kind of culturally passed down, so that those older magicians from the 15 or 1600s, would they have had apprentices that they would then pass their knowledge to? And so is there a cultural norm about that? And today, a lot of what we have to do is contractual agreements. As Native people, we do contractual agreements, but we're basically tying into cultural norms about how knowledge transmits, so that your apprentices don't steal your knowledge. And it's really a horrible thing for us to have to do that, because the contract is not a cultural manifestation for us and by any means, but oftentimes it turns out that way. So I was just struck by perhaps that was a tie-in to yours.
Yeah, that's beautiful. It's exactly right.
So back to your question, Sarah, on 2 levels we're talking about being underserved. The individual Native artists, and I'm pulling on a report that was just authored basically by First Nations in terms of the economics of this. And their report actually looks at Native arts economy on the reservations, says estimated 30% of all Native people are practicing or potential artists. Of that number, 61% earn $10,000 or less per year.
Wow.
So extreme poverty. The other thing is that approximately half of those people live on reservations such as Pine Ridge that are very far from the centers of commerce. And so therefore, the question is, well, how do they sell their work? So they end up selling at these really small portions. And if you go to Santa Fe, New Mexico, you're going to see that item, you know, that somebody went to Pine Ridge and bought for $30 and all of a sudden is marked up to $3,000 in Santa Fe, New Mexico. Well, that artist doesn't have access to that market. Mm-hmm. And so 79% of Native artists are drawing on traditional art forms for their inspiration, whether that's beadwork, it's basketry, kachina making, whatever, rugs. So it's a cultural art form, but contemporary artists have their own distinctive style, flair, but it's not recognized as an individual creation because oftentimes it is this thing called a cultural expression rather than something that fits into the formal definition of art that's protected as an individual creation. So there are many, many appropriations of traditional Native art forms. Mm-hmm. But one of the things I'm doing is looking at the cultural commentary around what's art, what's culture, and how is that produced within the tribe? How is it transmitted intergenerationally? What are the cultural norms about that? The other thing that the report finds is that while a lot of artists across the United States use the internet to market their art, I mean, they're starving artists too, but they use the internet. A lot of these households don't even have access to the internet. Sure. And if some of them put it on the internet, it can get snapped up and turned into somebody else's depiction of that item. So there's a certain amount of theft and appropriation that happens by marketing your artwork on the internet. If you're under $10,000 in income, you can't hire a lawyer to go out and fight your case for you. It's just not going to happen. So their rights, even as artists, in the sense that both of you have discussed them, they're not going to be able to actually get enforcement of a lot of the rights that are situated. So that's kind of a snapshot of the individual Native artist in terms of this rubric of being underserved. On the community level, the logic of the Indian Arts and Crafts Act of 1935 was to protect American Indian and Alaska Native nations from having non-Indians take rug designs, etc., go to China or whatever, and have somebody mass produce a Navajo rug and then sell it as a Navajo rug for $50, and the Navajo artist is spending, you know, however many hours trying to get a livable wage. Congress held hearings in 1935, said this is a huge problem, so they passed the statute. The statute was revised in 1990. The original form made it a misdemeanor. You had to pay maybe $500 in a fine if that's what you did. And of course, the poaching happened, you know, pretty much unabated throughout the 1990s. And so you had artists basically, you know, complaining that you know, you go into the art market, nobody could tell the difference between a Navajo silver bracelet and some other silver bracelet, right? Same design, same. So Congress tightened that up. But it's very difficult to prosecute those cases. Tribes can prosecute them. There are civil and criminal penalties. The criminal side goes to enforcement by the federal government. I was an informal consultant for the Indian Arts and Crafts Board for about 5 years during the era where they were developing regulations and looking at the harms. And I can tell you guys for a fact that appropriation continues unabated because it is so hard to bring an enforcement action. The success stories have been with tribes that have a lot of money, can hire great lawyers, and go after deep pockets, like J.C. Penney, that was marketing Indian art that wasn't Indian art. It was mass-produced. So yes, there have been substantial judgments. Right now, people have become much more cagey about that. And so the issue there is whether or not, and this is a form of trademark, the statute says you cannot represent that this is an Indian product unless you're an Indian artist. And they define Indian to be members of federally recognized tribes or descendants as long as they have basically the validation from the community that they belong to. So Indian product, well, what's an Indian product?
Mm-hmm.
There are many, many arguments about that. So I've been to New Zealand, and I've been to Hawaii, and I've been to Alaska, and a lot of what is happening now is Native peoples coming together and saying, what are the norms about cultural production? Is there a cultural trademark? And this isn't an Indian product, right? This is, for example, in New Zealand, they do that with the Maori mark. It is a cultural trademark, and the standard is defined by Maori people, and there's a corporate essence to that, which is how it's come into the modern economy, where the Maori people own the rights to the mark, and they can license or they can sue if you violate their mark. So it's partly geography, partly culture. And Hawaii's been experimenting with that too, because a lot of what they do, for example, hula dance, and the traditional healing ceremonies of Native Hawaiian healers, they're in a sense, and I hate to use the word, I honestly hate to use this word, but they're in a sense performance.
Mm-hmm.
But they are sacred performance. Hula is actually a sacred performance, and so are the appropriation of those performances is a cultural type of a harm in addition to the economic harm. In this country, you guys may have heard about the sweat lodge ceremony out in Sedona, where a bunch of people died. A non-Indian was running this and turned up the teat so high, and the people died there. That's just an example of a ceremony that somebody appropriated, misappropriated, did the wrong thing, and they were suffering. After that happened, a bunch of us in Arizona were getting calls about why did the government let Native people have this barbaric ceremony. It wasn't even a Native ceremony. They had appropriated that, and not correctly, to the detriment of the people who attended that, the victims. So that's an example of some of the things. Alma, also, in closing, I want to thank you so much for your work. It's very powerful, as is Jared's. One of the things that you mentioned was that the auction houses have this responsibility, and you mentioned the European Union having this responsibility now by their collective to pay the resale royalties. And I was fascinated with that. And you guys may have heard the news story about the appropriation of sacred Hopi masks that were sold by a Paris auction house for thousands and thousands of dollars. These are sacred items. And when the Hopi went there with the help of a wonderful attorney, an attorney in Paris, a French attorney, he was trying to make arguments, and now I see part of the construction of his argument. It was very unique and it was very impassioned. It was also ultimately unsuccessful under French law. But now I see he's tracing what you are saying. So he was saying the current Hopis are the beneficiaries of these items that were probably created in the 1930s, from what we can ascertain. The Hopis wanted them back because they're sacred and they should not have been commodified and sold on the market. So they're not art, they're sacred objects. But the Paris auction house said, no, they're art, and said, furthermore, they are cultural objects, and not in the sense that they're ancient, they are not tied to any living artist. So they have become art for a whole market that operates in the year 2013 or whenever that happened. They are no longer what they were created to be. And that was a very troublesome holding to me. So Alma and Jared, you guys have given me many things to think about. Yeah. You can tell that my article it's in draft, and I'm going to admit it. I need to learn a whole lot more to make a compelling case for what I want to argue, and I want to thank both of you. I want to thank Sarah. Thanks.
Well, thank you so much, everybody. And I know we went a couple minutes over, but I'm glad everybody got to talk. And I think it's wonderful to see that there were connections here that we weren't expecting. And so I encourage all of you to reach out to each other. And I want to thank you for participating in this panel.
Thank you for organizing, Sarah. I really appreciate it.
Thank you.
Sarah, thank you. I just wanted to say in closing that there's a common theme here of exploitation.
Yeah.
And when we look at how Native culture is being exploited in the art market, how creators of original art and magic are being exploited in after sales that they have no participation in, I think there's a really important cultural dynamic that we have to self-examine in terms of how American society is treating creativity in many different levels.
I agree.
Thank you for putting us together. I think it was very